Roll call for Tuesday, March 22nd, Legislative Day 24. Anderson? Baldwin? Whitman? Boner? Bouchard? Case?
Present.
Cooper?
Here.
Driscoll? Ellis? French? Murphy? Guru? Hicks?
Here.
Hutchings?
Here.
James?
Here.
Kinski?
Here.
Kolb?
Present.
Guru?
Here.
Driscoll?
Here.
Landon?
Here.
McEwen?
Here.
Nethercott? Pappas?
Here.
Boner?
Here.
Perkins?
Here.
Rothfuss?
Here.
Salazar?
Here.
Schuler? Scott?
Here.
Steinmetz? Wasserberger?
Here.
President Dockstetter?
Here.
29 present, 1 excused.
Heard today by Reverend Marston, First United Methodist Church. Heard today by Reverend Mark Marston, First United Methodist Church. Go ahead.
Yes, sir. Let us pray. Our Lord in heaven, we give you great thanks for giving us this opportunity to serve you and the people of Wyoming. Be with us on this day that we might build bridges where there are gaps, that we might listen where there is confusion, that we might bring peace and be both peacekeepers and peacemakers. Help us to walk in your ways, O Lord. Help us to unite and find common goals. Bond us with humanity as we are called to be your children. Help us to work in ways that are pleasing in your sight. For these things we pray through Jesus Christ. Amen and amen.
Pastor Senator Baldwin, would you get us started on the pledge?
And to the republic for which stands one nation, indivisible, with liberty and justice for all.
Reading, correction, approval of journal. Will the reading clerk please read the journal committee report?
Mr. President, your Journal Committee reports that the Journal of March 22, 2021 has been read and recommends that it be approved. Senator Kolb, Chairman.
Any objections? There being none, the report is adopted. Reminder that we are using the University of Wyoming Medical Family Practice for assistance if needed. We have the phone number here. Appreciate Reverend Marston for helping us today with the prayer. Today in Wyoming history, on this day in 1942, the U.S. government begins moving Japanese Americans from their West Coast homes to detention centers that would ultimately include Hart Mountain near Cody. Quote for the day from Lou Holtz: "Virtually nothing is impossible in this world if you just put your mind to it and maintain a positive attitude." Session status: today is the last day for second reading in the House of Origin. Tomorrow is the last day for third reading on bills in House of Origin. Before we go to messages, I'm just going to take the privilege of the floor for just a moment. Members of the Senate, I would ask these students to stand up in the chambers up here. These wonderful, great-looking, good-looking, above-average, strong students made a 7-hour bus trip over here to watch the proceedings of the House and the Senate today. Welcome the Star Valley Middle School government students from all the way over in Star Valley. Welcome to the Senate. Messages from the House.
From the House of Representatives, March 22, 2021. Mr. President, the following bills passed the House on third reading. Message number 225, House Bill number 190, vehicle titles for non-resident owners, ayes 58, noes 2. Message number 227, House Bill number 217, Community Health Center and Rural Health Clinic grants, ayes 53, noes 7. Signed, Wendy Harding, House Chief Clerk. Mr. President, the following bills passed the House in an amended form. Message number 223, House Bill number 166, Utilities Presumption Against Early Facility Retirements. Ayes 49, noes 10, excused 1. Message number 226, House Bill number 207, Coal-Fired Generation Facility Closures, Litigation Funding. Ayes 53, noes 7. House Bill number 229, I beg your pardon, message number 229, House Bill number 165, Wyoming's Tomorrow Scholarship Program, ayes 44, noes 16. Message number 230, House Bill number 236, Firearms Transactions, Financial Discrimination, ayes 49, noes 11. Signed, Wendy Harding, House Chief Clerk. Mr. President, the following bills failed to pass the House on third reading by the votes indicated. Message number 224, House Bill number 171, Executive Branch Funding Restoration, ayes 30, noes 30. Message number 232, House Bill number 125, Simulcasting, ayes 23, noes 37. Message number 233, House Bill number 164, Grand Teton National Park Transfer of State Lands, ayes 24, noes 36. Signed, Wendy Harding, House Chief Clerk. Mr. President, the House adopted the Committee of the Whole reports, failing the following bills by the votes indicated. Message number 234, House Bill number 146, Personal Property Depreciation, ayes 24, noes 36. Message number 235, House Bill number 175, Suicide Prevention 2, ayes 26, noes 32, excused 2. The bills have been indefinitely postponed. Signed, Wendy Harding, House Chief Clerk.
Reports from standing committees.
March 22, 2021. Mr. President, Committee number 9, Minerals, Business and Economic Development, to whom was referred House Bill 64 engrossed, Uniform Fraudulent Transfer Act, extinguishing claims. Respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, and Wasserberger. Excused, Senator Rothfuss. Senator Anderson, Chairman. March 22, 2021. Mr. President, Committee number 9, Minerals, Business and Economic Development, to whom was referred House Bill 68 engrossed, Wyoming Statutory Foundation Act amendments. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, Chairman. March 22, 2021, Mr. President, Committee number 9, Minerals, Business and Economic Development, to whom was referred House Bill 104, Uniform Trust Code Amendments. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, Chairman. March 22, 2021, Mr. President, Committee number 8, Transportation, Highways, and Military Affairs, to whom is referred House Bill 21, Wyoming National Guard Preference for Education. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Landon, Chairman. March 22, 2021, Mr. President, Committee number 8, Transportation, Highways, and Military Affairs, to whom was referred House Bill 22 engrossed, Wyoming Military Code. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Landon, Chairman.
Bills on second reading. Senate File 28, second reading in the Senate file.
Senate File 28, Motor Vehicles, Security Interest Perfection.
Senate File 28, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 81, second reading of the Senate file.
Senate File 81, Second Amendment Preservation Act.
Senate File 81, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 104, second reading of the Senate file.
Senate File 104, Anesthesiologist Assistance.
There is an amendment. Read in the amendment.
Senate File 104, Second Reading Amendment Number 1, page 17, line 3, delete.
Senator Hutchings.
Thank you, Mr. Chairman. I'm going to withdraw that amendment. That was the same as the one yesterday. Thank you.
Thank you. Second reading amendment number 1 to Senate File 104 has been withdrawn. Senate File 104, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 112, second reading of the Senate file.
Senate File 112, Insurance Discount for Accident Prevention Training.
There are no amendments. Senate File 112, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 121, second reading of the Senate file.
Senate File 121, State Funds, Investments and Distributions.
There is an amendment. Read in the amendment.
Senate File 121, Second Reading Amendment Number 1 to substitute Bill Number 1, page 1, line 1, delete.
Senator Kinski.
Thank you, Mr. Chairman. I would move second reading amendment number 1 to Senate File 121. Folks, this is identical to the amendment that we considered yesterday, but we had some folks off the floor, and so I thought it might be worth revisiting the debate briefly. Whether it'll change the outcome or not is an open question, but I think it's worth running it up the flagpole. And so to remind you, I think this bill is a very good bill, getting rid of the SIPA fund and trying to simplify some of our revenue Rube Goldberg structure. My concern is that over several sessions, we worked hard to get the spending policy stepped back from 5%. In a couple of years, it's going to step back to 4 3/4%, and thereafter it's step back to 4.5%, which makes it more likely, unless we intercept money, that funds will flow to the corpus of the two funds, the Common School Public Land Fund and the Permanent Mineral Trust Fund, thereby bolstering them against inflation and more equitably spreading that money across the generations. And I'm afraid that if we up the spending policy, we do so at the expense of future generations. We had hearings in Capital Finance where we learned that the earnings we've had historically are not what we're going to have going forward. And it was recommended that we, in fact, step these earnings down, which has been done. This bill, for all its good attributes, the one negative is that it's going to reverse that decision and restore the spending policy back to 5%. And this amendment would keep the current policy that says we're going to start stepping that spending policy down to help instill some fiscal discipline upon the legislature, albeit 2 years out. With that, I would urge an affirmative vote on the amendment.
Questions on the amendment? Chairman Perkins.
Thank you, Mr. Chairman. On and against the amendment. Ladies and gentlemen, that step down came through the Capital Finance Committee about 3 or 4 years ago. In the meanwhile, what's been the effect on the funds of keeping it at 5? And in fact, that was supposed to happen, and we've negotiated away that rejection or that step down several times over the last 3 or 4 years. What's been the result of the effect on the funds themselves? They've continued to increase. The ones that have been mostly affected by this, Wyoming Permanent Trust Fund. Again, I would point you back to the bill itself. Even though it's a 5% spending policy, the only thing is guaranteed with that 5% spending policy is 2.5%. So even if you do a step down reduction, it has really no effect on the spending policy itself. The spending, again, going back to the spending policies mostly at this point, particularly with the Permanent Trust Fund, only work to provide a tip through the reserve account. And so you get a 5%, and if you have 150% of 5% of the spending policy amount. And when you get that much in the reserve accounts, then if they're over that, then they tip. The spending policies typically aren't really spending policies because you reduce them or increase them. Doesn't necessarily mean you spend a dime more or a dime less. What's doing that is other parts of the statute that provide guarantees. And the bill as it is already actually removes any guarantee that there was on the permanent trust fund. It doesn't really affect the guarantee because it's a different part of the statute on the common school permanent land fund. Out of all the funds have continued to increase. About the only one that wasn't able to meet its obligation a few years ago was the Excellence in Education Endowment. And it really didn't have anything to do with the 5% spending policy. So there just hasn't, the crisis or the effect that we thought the stepping down the spending policy would have really hasn't been realized. It hasn't been, and it hasn't really harmed the funds themselves. And so even if you step it down, the other side of that is it, when you look at this, are really going to save, is it really going to help the generation? And when you look at generational equity, is to find the equity, a fairness between spending now and spending and saving in the future. And we're trying to find that balance. And there's no indication at this point that stepping this down affects that balance favorably, unfavorably. It'll obviously favor it in front of future generations to some degree because it will lower the tips when the accounts get so full. But the other thing that's important about this, because of most of these spending policies mostly affect the tips. They really don't have much effect on spending. And going back and looking since 2004, if you look at the amount that tips when these reserve accounts get full and tip over, the amount that's tipped over, even with the 5% spending policy, has been $589 million is tipped, even with the spending policies at 5%. However, what's been the effect of saving, which is the other part of this bill, it helps direct savings into corpus. And at that same time, 1.5 billion has been saved, either from the 1% severance tax and the constitutional severance tax deposits to the permanent trust fund. So when we save it, it's not because you're rolling it over. The majority, 3/4 of all the increases in deposits to the corpus have been because of savings, and that's what this bill does. So you can do it, but it's not going to save in a bunch of money that ends up rolling into the corpus, because you save money by saving it, not by doing these rollovers. And every future, regardless of what these spending policies are, any future legislature can intercept the 1% severance tax. We have no ability to bind that, but this does put it so that it has to take affirmative action on both houses to change the course and the deposits from these 1% severance tax. So again, I don't think that the amendment is necessary, and it really doesn't help us save much more money at all. Thank you, Mr. President.
Further discussion on the amendment. We are on second reading amendment number 1 to Senate File 121. Senator Landon.
Mr. President, thank you. I've alluded before to the fact that I sat where the good senator is sitting now on the Appropriations Committee, and really want to tip my hat for all the work that the Appropriations Committee has done over this past year. I think about 5 years ago, the Appropriations Committee that you and I sat on together, we reduced that budget by, I think, $330 million. This time around, we're looking at a budget that is reducing by $450 million. My only caution to this amendment, and the reason that I'm going to vote no on the amendment, Mr. President, is with that kind of drawback, I think that we need a little bit of flexibility. And I think that the Appropriations Committee and the rest of us will appreciate if we allow ourselves that flexibility in case we have gotten out over the front of our skis a little bit too far. And that could happen, because when we draw back to the tune that we are this year, we may run into some things back home that we had no idea we were going to run into. So for that reason, I'll be on and against the amendment. Thank you.
Thank you. Further discussion on the amendment. Senator Hicks.
Yeah,
Mr. Vice President.
Mr. President, just for a little bit of clarification, even if you defeat the amendment, and adopt the bill, it's a running 5-year average. And the projections we've seen there still will be a little bit of a step back from the spending policy. So just want to make clear on that even the bill, because it looks at the 5-year previous average, will reduce that 5% back some. I don't have those exact numbers in front of me, but we've seen those projections for budget and fiscal. So just wanted to make sure that was clear, Mr. President. Irregardless if you adopt the amendment or you don't adopt the amendment and pass the bill, there'll still be some minor step back in that spending policy from 5%. It'll go down to 4.7 or 4.8 or whatever that number is.
Further discussion on the amendment. Further discussion on the amendment. Let's go back to the sponsor, Senator Kinski.
Thank you, Mr. Chairman. So part of your determination on how to vote depends on whether you believe that a record 12-year bull market is going to continue. Briefly interrupted by the COVID crisis, the markets continue to shoot up, fed by a printing press in Washington, D.C. There will come the day when the Fed has to start ratcheting back. And instead of a 12-year bull market, we may be looking at a 3 to 4 to 5-year bear market. And that's important to understand because my friend, the chairman says, well, the corpus has continued to increase. Well, of course it has. We've been in a Federal Reserve Fed frenzy in the stock market, as Alan Greenspan once called it, irrational exuberance, where valuations are way above what any rational market analyst can support. For the same reason, it appears that we actually are spending less than 5% because you're looking at a 5-year rolling average of the corpus. And as long as the market's going up, it appears like we're spending less than 5% based on the current value. But if the market goes down, it will appear like we're spending 5.5% or 6% or 6.25%. So I guess what I'm asking is, we had a rare moment of fiscal discipline where both bodies and the governor agreed that we needed to step down our spending policy. That rather than 5%, we're going to step back to 4.75%, 4.5% to instill some discipline. And then, elected bodies doing what elected bodies do, thought different and postponed that. And then when the money was supposed to tip into corpus, grabbed, intercepted, but hope springs eternal. If we keep this step back on the books, that as we come to realize that we can't continue to spend the way we have historically, there may come a day where we decide not to keep intercepting those tips, where we decide not to keep postponing the step down. And we force ourselves to face the reality of our economic situation and bring discipline to the process and fairness to future generations. I'd urge an affirmative vote on the amendment.
Ready for the question? Question being called. This is on second reading amendment number 1 to Senate File 104. All those in favor say aye. Aye. Those opposed, nay.
No.
Chairs in doubt. All those in favor stand. All those in favor stand.
Opposed.
Oh, opposed, excuse me. Fails on a 15-15 tie vote.
Third reading.
Third time's a charm, Kinski. Matter up.
All righty. Senate File 121, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 127, second reading of the Senate file. Oh, Mr. Vice President,
If they keep that up for one more reading, they might get it, but let's just hope they don't.
certainly been trying, certainly been trying.
Need
Okay.
another vote.
Senate File 127, having been read, or Senate File 127, second reading of the Senate file.
Senate File 127, Wyoming Learn While You Earn program.
There are no amendments. Senate File 127 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 138, second reading of the Senate file.
Senate File 138, School Board Trustees Party Affiliation.
There are no amendments. Senate File 138 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 139, second reading of the Senate file.
Senate File 139, Community-Based In-Home Services Program.
There are no amendments. Senate File 139 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 141, second reading of the Senate file.
Senate File 141, Business Entities Representation in Detainer Cases.
There are no amendments. Senate File 141 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objections, it is so ordered. Bills on third reading and final passage. There's no consent list. We'll go straight to one bill. Senate File 145, third reading of the Senate file.
Senate File 145, Election Runoffs, an act relating to elections sponsored by Senator Beitman.
Senator Beitman.
Thank you, Mr. President. I would ask that Senate File 145 be laid back for one day, please.
Senate File 145, election runoffs, absent objection, laid back for one day. Consideration of bills on general file. Mr. Majority Floor Leader, we are at that order of business. Consideration of bills on general file.
Mr. President, I move that the Senate resolve itself into committee of the whole.
You've heard the motion. All those in favor say aye.
Aye.
Those opposed, nay. Motion passed. Senator Kolb, you are now in charge of the Senate for the very first time in your life.
Oh, they'll have these bills up. You- Bills to hand you what they. Thank you. The Committee of the Whole will please come to order. The first bill for our consideration is House Bill 121. 127? Oh, I thought, oh, well, thank you, Majority Floor Leader. I'll restate the first bill for our consideration is House Bill 7. The reading clerk will read House Bill 7.
House Bill 7, Air Ambulance Membership Organizations Regulation, an act relating to insurance sponsored by the Minerals Committee, was referred to Committee Number 7, which returned a committee recommendation that it do pass amended. Ayes, Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chairman.
Senator Anderson? Driscoll. You're the, oh, all right. Excuse me, Senator Driscoll.
Mr. Chairman, I move with the committee of whole rises to report it, do so of the recommendation that Senate House Bill 7 do pass. It has amendments. I ask it to be read in, and for further explanation, I will call on Senator Nethercott.
Senator Nethercott.
Thank you, Mr. Chairman. There is a standing committee amendment. If I can have that read in.
House Bill 7, Standing Committee Amendment number 1 to engrossed copy, page 4, line 18 after.
Thank you, Mr. Chairman. Good senators, you have in front of you House Bill 7, Air Ambulance Membership Organizations. As you can tell, this is from the work from the Joint Minerals Committee. Your number 7 committee did look at it in this session, but it's a concept we are familiar with throughout the course of the last couple of years with concerns over these air ambulance memberships. Historically, we had concerns and we heard from constituents about the need for their ability to access air ambulance services and how those services are provided. There were providers in our state providing these services through memberships as opposed to insurance type guarantees. And as a result of some of those, some confusion surrounding what those services actually provided and how they worked for the constituents and the people of Wyoming, this particular bill came forward as a result of a compromise really for the need of providing these services combined with the need for appropriate regulation. I'm not sure that we're there yet, but this bill is a start. So good senators, that's the bill, and I can walk through with it with you, but I'm also going to go to the amendment right now, the standing committee amendment. One of the concerns about these corporations that provides these memberships for air ambulance service is that they may not have the consumer protection requirements that we would typically associate with these types of businesses. And so this amendment addresses those concerns. And so you can see on page 4, line 18, we add the provision that the applicant for an air ambulance service provider is financially responsible. We put in there further limitations associated with them being subject to the Wyoming Consumer Protection Act. We add further provisions associated with on line 19 of the amendment that if the air ambulance service is at risk of insolvency or otherwise being financially unable to provide air ambulance service to its members as required by the terms and conditions of the membership plans sold to Wyoming residents, again, requiring that these corporations are actually financially solvent to provide the services for which they are selling. Then further, moving on down that amendment, that the commissioner, which we're talking about the Department of Insurance, may conduct examinations of air ambulance membership organizations for compliance with these particular provisions associated with whether or not they're properly collateralized, have the ability to actually do what they say they can do. Further requirements moving down the amendment associated with what these corporations, these businesses need to tell consumers about what they're actually selling, ensuring that the consumer understands what they're purchasing, how those communications are to be provided. They can be provided via mail or email or directly to the person. If you look at the membership of the committee number 7, I think that you'll be impressed to see that we added the provision for email being an allowed form of communication. Of note, further definitions found below of who a person is under the act, and that includes all affiliates of the entities referred to in the definition. What we have seen across the country with these corporations is that they have many affiliates. So frequently you can see many subsidiaries of those corporations, adding further concern regarding their solvency and regarding whether or not they can actually provide the services for which people are purchasing. With that, I would stand for questions on the amendment, which are really consumer protection amendments, and ask for your favorable consideration on the amendment. Question on the amendment, Mr. Chairman.
Question being called. All those in favor of Senator Nethercott's motion to adopt Standing Committee Amendment number 1 to House Bill 7, please say aye. Opposed, no. The motion to adopt Standing Committee Amendment 1 to House Bill 7 has passed. Oh, I did? I said, oh, okay. Well, let me back up. I'll call for the noes. Thank you. Excuse me. No noes. Oh, thank you. The motion to adopt Standing Committee Amendment number 1 to House Bill 7 has passed. We are back on the bill. Senator Nethercott.
Thank you, Mr. Chairman. Back on the bill, good senators. I don't think this will be the last of this conversation for the legislature. This continues to be an area of concern. I do just want to bring to the body as a topic of conversation going on that just as of this past week, the Eighth Circuit issued an opinion regarding, I believe, the state of North Dakota similar law concerning this issue. And I apologize, Mr. Chairman, for providing the name of the state. But they just issued similar, same set of facts, essentially occurring in that state. The legal issue presented to the Eighth Circuit, slightly different than what we're dealing with right here. But I think it's very, very important for this body to recognize that the Eighth Circuit held that the federal law concerning the regulation of air ambulance providers actually applied, and the state's effort to try to nullify the federal law was unlawful. Something for the body to pay attention to and concern about whether or not this legislation would actually be effective as a result of the federal law associated with the regulation of air services in this country. Just for your consideration and thoughts. We all know.
Mr. Chairman,
Senator Scott.
Mr. Chairman, a little more history on this one. For a number of years, the state has been involved in trying to deal with air ambulance. First came to our attention when I was in Committee 10 because the workers' comp people were trying to get reasonable rates out of air ambulance, same as they do with all other providers. And the companies took them to court, refused to abide by the schedule that workers' comp uses for compensation. And state of Wyoming took that to the 10th Circuit Court of Appeals twice and lost. The reason is that the air ambulance people got included under the Airline Deregulation Act, even though their business is so fundamentally different, because you don't really have much choice on provider or need when you need one, because you need them real bad. But the federal government preempted any regulation of rates by the states. We tried to get around that because the feds had sensibly exempted all their programs from this kind of regulation. And that includes Medicare and Medicaid, and we participate in Medicaid. We tried to get around it that way. That didn't work because Medicaid wouldn't cooperate federally. But as a byproduct, we asked for the companies that sold these memberships to be registered with the state insurance commissioner as if they were an insurance company. And we had heard some complaints that you could be a member and get covered by one of the companies, but if somebody else happened to be the one that came when you needed an air ambulance, you were just out of luck. You got stuck with full bills over which we had no control and which could be very expensive. We thought that these companies would register. We'd find out who was out there and maybe get some regulation on some of their marketing practices. Instead, they initiated a campaign to get the law overturned. And a number of us got inundated. I couldn't use my telephone for anything else for 2 weeks as a result of that. It was quite a campaign. And we discovered, Mr. Chairman, that not only was the problem that we were aware of, where there are multiple providers in the state and your membership only covered the one you happen to have the membership with and not the other 6 or 7. And you had no control over who came when you needed a company because the dispatchers will send, especially in an emergency, the one that is most available, and who may or may not be who you're dealing with. We knew about that problem. We discovered they were marketing very heavily to senior citizens. I would guess that 70 or 80% of the calls I got were from people who had coverage with Medicare. And Medicare regulates the rates and forbids balance billing over 20% of their regulated rate. And Medicare provides the coverage. So many of those senior citizens, particularly the ones that had a decent Medicare supplement policy, would never be able to use the membership they were being sold. It's a heck of a thing, Mr. Chairman, when, I don't know, I guess I don't want to call it a scam, but when people that are marketing to people who really can't use the product can get their customers to call up and complain. So the net result was this bill, courtesy of the Minerals Committee. It doesn't solve all the problems. It does require that they do register with the insurance department. It does require with the standing committee amendment some solvency requirements. Those are probably not as important as some of the other provisions. We think it gives the insurance department some ability to police marketing abuses and prevent potential scams. It does not solve the problem of the coverage only applies to the company that sells the membership. So it doesn't solve all the problems. It's part way. It's probably a step in the right direction and a reasonable compromise. And it is a different set of facts than the North Dakota situation, where they totally banned, my understanding, the sale of these kind of memberships. This is different. It doesn't seek to regulate prices, but it does seek to control some marketing practices. I think it'll probably stand a court muster, but we've been wrong before. What we really need is a change in an unreasonable federal law, and the Congress is incapable of doing anything like that, apparently. So it's been a real problem, real source of increase in healthcare costs in the state. This isn't a perfect solution, but it's the best one we've got.
Are you ready for the question? Oh. Senator Cooper.
Thank you, Mr. Chairman. There's some instances in the state, some counties that there's some counties in the state that utilize this as a backup for their ground ambulance and purchase the membership countywide for their residents. Rural counties where air ambulance is critical. And it provides a backup for ground ambulances in that area that is essential for the rural communities we live in up in that country. It saved countless lives to have them there. When you're an hour to an hour and a half away from an ambulance, this is just critical that we have this kind of service. And the service is provided via the county to the residents at no cost to the residents. So it's a good deal for the people that are out there utilizing it. There are some, like the good senator from Faith Hole spoke, there are some companies out there that use high pressure sales to sell their memberships. So that consumer protection that's involved in this is critical. It is important. And this seems to cover that. One thing to remember that this is not an insurance now. It is, they're registered with the Insurance Commission, but it is not an insurance. An insurance company would be required, an insurance policy for air ambulance would be required to guarantee service. An air ambulance can't guarantee service because of weather. So they do their best. They provide the service for rural communities, but and there is consumer protections involved in this. It is critical for our rural communities to have access to these things on and for the bill.
Senator Driscoll, there is a committee of the whole amendment. Could you explain that?
Could we have it read in, please?
Could we have committee of the whole amendment number 1 read in for
House Bill
House
7.
Bill 7?
House Bill 7, Committee of the Whole Amendment to number 1 to engrossed copy, page 15, line 3, delete.
Mr. Chairman, I move committee of the whole amendment number 1 to House Bill 7. Folks, this is basically a technical correction that staff picked up. Merely on page 15, line 3, they delete act and insert article just to get it into alignment with existing language and statute. So I'd stand for question, and ask for your favorable consideration.
All those in favor of Senator Driscoll's motion to adopt committee of the whole amendment number 1 to House Bill 7, please say aye. Opposed, say no. The motion to adopt committee of the whole amendment number 1 to House Bill 7 has passed. We are back on the bill. Senator Furphy.
Thank you, Mr. Chairman. Just a question. Looking through the bill, I don't see the amount of liability insurance in the event the transport would have an accident while they had a patient on board. Was that discussed in committee? Thank you, Mr. Chairman.
Senator Scott.
Mr. Chairman, I do not recall any discussion on that issue in any of the committee meetings on this. It is a risky business. They've had some very bad accidents where they lose not only the patient, but the helicopter crew and the medical personnel involved. And they've developed quite a good deal of caution and respect for Wyoming's weather and consequence. It is a risky business. I'm sure that insurance is a cost of the business. But, Mr. Chairman, because the federal government forbids us from regulating rates in any way, we didn't get into the matter of what their costs were. It is going to be expensive. The information we have is some of the bills are way more than what the expenses are, but we can't deal with that, so we never investigated it very thoroughly, Mr. Chairman.
Senator Rothfuss.
Thank you, Mr. Chairman. On and for the bill, we did work this in the Minerals Committee during the interim as a joint interim committee bill to address the concerns that the good tall senator from Natrona County discussed. And it's a partial solution. It's helpful. It doesn't come close to probably solving the problems that we have because we're largely excluded from solving those problems as a state due to federal preemption. This is only regulating the membership organizations, not the air ambulances themselves. We can't really touch those air ambulances and how they bill or really anything about them due to federal preemptions. So it's a good step in the right direction, and obviously a lot more work needs to be done. Maybe we can come up with some more clever solutions. There was a good bit of hope a few years ago that the Medicaid solution that the tall senator mentioned would be effective, and honestly, it could probably be attempted again. Different people, different time. Maybe it would go better this point in time, but I'd urge the body to support this and appreciate the good work by the Corporations Committee on improving it. Thank you, Mr. Chairman.
Sensing you're ready for the question, all those in favor of Senator Endicott's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 7, say aye. Those opposed, no. House Bill 7 has passed committee of the whole. The next bill for our consideration is House Bill 4.
House Bill 4, Mental Health Professions Practice Act Amendments, an act relating to the Mental Health Professions Practice Act, sponsored by the Labor Committee, was referred to committee number 10, which returned to committee recommendation that it do pass. Ayes, Senators Baldwin, Bouchard, Furphy, Hutchins, and McEwen. Senator Baldwin, Chairman.
Senator Baldwin.
Mr. Chairman, I move when the committee of the whole rises to report, to do so with the recommendation that House Bill 4 receive a favorable recommendation. For explanation of the bill, I turn to Senator Bouchard.
Senator Bouchard.
Thank you, Mr. Chairman. Members, what we have here is a bill, Mental Health Professional Practice Act amendments. And all we're doing here is we're taking another section where things are in another section of code, and we're putting them back in another section and making it all uniform for practices that are similar. So starting on the front of the bill, mental health professions practice, providing for criminal background checks. And that's what we're doing here, making sure that they all take uniform background checks. We had some that were 5, some that were 4. We're doing it all, where they're all doing it for 4 years. Providing for standards for a certified mental health worker. That's the one that was in a separate section. We're moving it over into a uniform section that's in its own place, where all these people are going to be under the same code. Creating new paragraphs, creating new sections on page 1. Next page, background checks. That's how it's all going to be uniform background check language. On page 3, we're including the definition of certified mental health worker. That's who's getting moved in here. It has some standards of what happens with that worker, common language, not being able to diagnose or acting as a primary treatment provider. You'll see a lot of that same language with addictions professionals. You'll see on the bottom of page 3, it's human behavioral discipline refers to as a degree in addictionology, criminal dependency, substance and use disorder counseling, psychology, social work. So basically what we're doing is moving that definition into that whole block. On page 4, how the process works in a background check is basically what we're outlining here. Come down the next part of that page, requirements for licensure, just basically making that more uniform. Page 5, establishing standards. That's pretty much on all of page 5. You can see that language about not having felony convictions. As we go down further, meets academic and training content standards established by the board. Go on to the next page, more the same at the top. The board may develop and adopt, administer appropriate examinations. So again, this is just making this all uniform for the mental health practitioners. On the end of page 6, reciprocity, pretty big deal here. We've had a lot of discussions on this. This is kind of going to bring it all to where we've had different practices have different reciprocity standards. This is going to make it more uniform for all of these practitioners. As we go down to last page, more policy and how that works to meeting requirements. And then we've got the repealer. This 3338-106 is where this one practitioner was that's basically defined in this bill. They were in that section. We're moving it over to this new section. So that's the repealer. So I'll stand for any questions.
Question being called. All those in favor of Senator Broussard's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 4. It's the chairman. Oh. I'll restate. All those in favor of Senator Baldwin's motion that when the committee of the whole rises to report it, do so with favorable recommendation at House Bill 4. Say aye. Those opposed, no. House Bill 4 is passed committee of the whole. The next bill for our consideration is House Bill 91.
House Bill 91 engrossed removable of unenforceable property covenants, an act relating to real property and conveyances, sponsored by Representative Duncan. It was referred to committee number 7, which returned to committee recommendation that it do pass. Ayes, Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chairman.
Senator Driscoll.
Mr. Chairman, I move when the committee of the whole rise to report, do so with the recommendation that House Bill 91 do pass. And for further explanation, I call on Senator Nethercott.
Senator Nethercott.
Thank you, Mr. Chairman. Good senators, House Bill 91, removal of unenforceable property covenants. What this bill does is it allows for the removal of unenforceable property covenants. Pretty simple concept. So when a provision in a covenant or in covenants associated with your real property or in a deed is termed to be unlawful, that there is no need to continue to perpetuate that unlawful provision in the deed or in the covenants. And so the new deed that gets filed upon the transfer or sale of that real estate can have that provision eliminated moving forward. That's what the bill does. Pretty simple concept, really great thing. And so with that, I'd stand for questions.
Senator Bashad.
Thank you, Mr. Chairman. I just have a question for the sponsor. If the covenant is there and the HOA wants to enforce it, and they haven't done so, let's say they haven't done it in 5 years, but then the HOA, would they lose this would kind of make it go away and lose that ability. So that's my question. I want to make sure that it's still there. So that way, if there's an action by an HOA, they can still do it.
Senator Hutchings.
Thank you, Mr. Chairman. My question is on these covenants. Number one, if they're unenforceable, why are we taking away, in my eyes, history? I kind of know a little bit about what's behind these covenants. Areas in my district have these covenants, and the covenants pretty much state that they will not allow Negroes to buy these homes. And it seems like everybody's offended, but the only Negro in the legislature. I'm not offended by these covenants. I believe people had the right in our history to do what they did. And for me, if I was to purchase a home in that neighborhood and I saw that in the covenants and saw that and know that it's unenforceable, I would find no offense. I would look at it as a way of, in my eyes and in my family members and the people I've talked to, a way of showing that we've overcome some of these old racial stereotypes. So my question is basically, what are we trying to erase in history? If they're unenforceable, why do we need to take them out? Thank you, Mr. Chairman.
Senator James.
Thank you, Mr. Chairman. I'm just curious, on page 334, 154C, why are we having the title companies, the brokers and escrow companies interpreting law when it comes to putting stamps on documents that when it comes to violating law? And also when nowadays, a lot of the paperwork is done digitally, and how are they supposed to put stamps on digital documents? Thank you.
Senator Kinsky.
Thank you, Mr. Chairman. Following on the heels of my last two colleagues, I was contacted originally by a constituent in the real estate business that was offended that one of these things was on file. And the conversation I had back and forth is, it's a dead letter. What does it matter? And he said, well, I don't want it to be seen. You know, I had a buyer that saw it. And I said, you want us to physically, what, go into the courthouse and yank that page out and erase it? And he said, yeah, nobody should ever have to see that. Well, this doesn't erase it because you can't just go into the clerk's office and start pulling pages out of the books. So this just says, you know, that dead covenant, it's truly uli dead, like the Wizard of Oz and the Wicked Witch. But it's a dead letter. Those covenants are absolutely dead. I don't understand the need for the bill, because the people that are offended that it's even of record, it's still going to be of record. There'll just be another document saying ignore the other document. So on and against the bill, and I could be convinced. I'm just not clear again with my other two colleagues why we're even doing this.
Senator Nethercott.
Thank you, Mr. Chairman. Well, we're doing this because your understanding of the process is incorrect. So the continuation of a deed goes on and is transferred from real property owner to real property owner for hundreds of years, including unlawful provisions from hundreds of years ago, 150 years ago, maybe even less than that, just 100 years ago. And so in order to keep the deed clean, in order to keep the deed good, because you are purchasing a warranty deed, and you're paying for a title opinion, which is also a legal opinion from the title company, to declare that you actually own the property in full with a warranty deed as opposed to some other type of ownership of the property. They have to make sure that there's been no alterations to the integrity of that deed. So it is a legal opinion. They are able to do so. They have lawyers working for them in title offices, and they take on that kind of title opinion, which is what you pay for a title when you go to close. They have to continue to perpetuate what that deed actually says. They are not in a position to change the deed. They are wanting the lawful authority to change those provisions in a deed or in covenants that have been determined by the Wyoming Supreme Court, the United States Supreme Court, or our state statutes that are unlawful to be removed. And yes, those provisions typically relate to the prohibition of those not of the Caucasian race to live in our neighborhoods in this state. That's the basis of the bill. To address the concern from my fellow senator from Laramie County regarding a concern over HOA covenants and waivers of enforcement of those, good concern, common occurrence that many HOAs have covenants within them that are not enforced. That does not deal with this bill whatsoever. This bill deals with only those provisions of covenants or deeds that have been determined by statute or by a court of law unlawful or unenforceable as a result of their underlying illegality, not from a lack of enforcement. So no concern there. So I hope I've answered the questions. The truth of the matter is, as of right now, in some of our neighborhoods in Cheyenne, purchasers of those properties have to initial and sign off on the deeds that say only those of the Caucasian race can live in this house. And whereas that's not true, and certainly that's unenforceable, they still have to initial and sign off on it. Why? Because you're concerned about erasing history. I assure you, history will be preserved forever, that those covenants were there. They are going to be there for the first 100 years that they could be found. And you can go back and look in real property records, state archives, and wherever else they may be located and recorded and find those unlawful provisions. But moving forward, as a result of them being found unlawful, there's no need to continue to perpetuate them. In my mind, this is not particularly very exciting, because as lawyers writing contracts and documents, when a term is found to be unlawful, we don't continue to write it in. If it's found to be unlawful, we eliminate it. We save on the typing costs, we save on efficiencies, and we just focus on those provisions that are actually applicable, so everyone understands what the law is and how it applies to them, instead of reminding them of an unlawful archaic provision that's no longer in existence and should not be.
Senator Hicks.
Mr. Chairman, a real quick question. and I understand the component when we look at that, it says prohibited by law, but if just a little deeper explanation as a determination of who makes the determination of an unenforceable covenant. So we've got the prohibition by law. So who is the response? And I get the whole thing about the penalty if you misrepresent an unenforceable, but just a little more detailed discussion of how you have a void and unenforceable covenant. I need to understand that a little better, please.
Senator Endicott.
Thank you, Mr. Chairman. Page 2, lines 14 through 19. Just take a minute. Let's go there for a second. All right. The standard for what is unenforceable would be 1, Romanet 1, is held to be void and unenforceable by a final determination of the Supreme Court of Wyoming or the Supreme Court of the United States of America. Check. Pretty solid. Not even a district court determination can make that void or unenforceable. Has to be a final opinion of the Wyoming Supreme Court or the United States Supreme Court. I think that goes too far really, but seeing where it is, I think that's appropriate. Or 2, if we say it is. So in violation of the acts prohibited by Wyoming statute 40-26-103 through 40-26-109. So if the legislature says it's unenforceable and unlawful, it is. Or if a court of law, the Supreme Court or US Supreme Court determines it to be unenforceable.
Senator Scott.
Chairman, and that law is the Wyoming Housing Act where we imitated the Federal Fair Housing Act so that we could have any cases on it resolved here in Wyoming rather than go outside. So it's an echo of the federal act, and it does specifically prohibit the kind of covenants that we do see here that are so offensive to so many people, and rightly so.
Senator Hutchings.
Still on and against the bill. I'm just wondering, why are people so offended by these words in history? If we start erasing our history, like we've seen in the past year, people tearing down monuments and defacing property and changing history so people don't get offended. I just don't get it. Again, when I see those words, I'm not offended. And I have not had one person come to me except for a young student. And by the time I was done with him, he thanked me for my comments because he got to see that they were possibly trying to do something that would forever erase history. And that's not proper, I think, Mr. Chairman. Thank you.
Senator Scott.
Mr. Chairman, in response to that, I think most of the offense comes when people are asked to sign that they will abide by something that they know is unlawful and that they think is immoral. And it's not the history that offends them, it's the act of having to sign that they will abide by it themselves when they don't believe in that.
Senator Burchard.
Thank you, Mr. Chairman. On and for the bill. Chiming in from what the senator from Bates Creek said, it's a real estate transaction. The history is not going to be erased. It's going to be there, recorded and written in history. These are things that are added on a title. And I can just tell you, as someone who's sold real estate, that it's just hassle. You don't need to be on a document at the time of a sale, and it doesn't need to perpetuate. I think all the questions have been answered about the other possible covenant restrictions. look, if they're illegal, they don't need to be written on a piece of paper and perpetuated. So I think it's a good thing. Let's I support the bill.
Senator Perkins.
Thanks. I do have a couple questions about, just practical questions about application. And so I think, and you may have already said this, and excuse me for being dense if I missed it, but particularly if you go to subsection C on page 3, where we have this, I think this will kind of highlight my question. And so you have this is what the instructions or the title company, escrow company, real estate broker, real estate agent, or association that provides a copy of any conveyance which violates WS 40-26-103 through blah, blah, blah. Affecting interest in real property to any person shall place a cover page or stamp on the first page of the copy stating, and then goes on that it violates this. So as I'm looking about this, and I understand it when the restriction is actually on the deed, not a problem. You know, this will authorize and make sure that the conveyance is not somehow invalid or deficient because that's been removed. I get that. But as we move forward, I mean, the other one is that I think that a lot of these, particularly if you get some of these older subdivisions, you have these restrictive covenants that are separate and apart from the deed. And so they're part of the record and they're incorporated into the deed by simply saying that it's subject to all restrictions and covenants of record. And so in a separate document, which is, might have been filed with the subdivision plans back when it's done, that you may have some of these offending and unenforceable covenants there that aren't in the deed themselves or the instrument themselves, but are incorporated by reference because they're made subject to that. And I'm just trying to figure out how that would work in this instance. And I mean, and if that's the case, I mean, wouldn't it be that, I mean, the other thing you do is simply also, because at the end of the day, it doesn't matter what the lawyers think, it matters what the title company will insure. And at the end of the day, why don't we just tell the title companies that they can't issue a title opinion, that they've got to create an exception to a title opinion. I mean, that might be another way to do it. And so just stop it and it just quit happening. But I'm just trying to figure out the practical application with respect to title companies and these deeds these restrictions that are incorporated by reference and how that would work.
Senator Rothfuss.
Thank you, Mr. Chairman. Two thoughts that strike me from reading through the legislation based on the debate. The first is the permissive language that we see really right at the beginning of paragraph A on page 2, which indicates that any person who holds an ownership interest of record in real property in the system, et cetera, may. And it provides for the opportunity for a new owner effectively during the transaction to opt based on property that they're then purchasing. It seems to me that this is consistent effectively with property rights, that we would implement this. If it's your property, you should have some decision authority really over whether or not you want to maintain this covenant. So if you do want to maintain the covenant, if that's something that sits well with you, then by all means, it seems that this is permissive language that would provide for that opportunity as the property owner. If you do not, then you would have the opportunity to not maintain that language, and it provides a procedure then that would allow you to strike that covenant from requiring your initial, even if it's not enforceable. From that standpoint, then it does seem like it's just consistent with good, strong property rights that I believe we all traditionally support. My understanding, and this is then a question to the prime sponsor, if I'm accurately understanding this, is that effectively the records that are maintained will not be changed. So the history, if that is concerned, it's my understanding that nothing will be expunged or deleted or eliminated. It's the obligation on the covenant to agree to the covenant that is effectively being removed for these non-binding covenants. So if the concern is a deletion of history, I believe the entire paper trail of all transactions previously will still be maintained in their traditional fashion of recordation. It's just, there's no longer that obligation, since it's not a binding covenant, to sign the binding covenant during the transaction. And so I would ask, is that a fair understanding, or if not, what nuances am I missing? If I'm inaccurate. Thank you, Mr. Chairman.
Are you ready for the question? Oh, excuse me. Senator Bouchard.
Thank you, Mr. Chairman. So just to recap what my fellow senator just said, think about someone buying the property and being told that this is what you have to agree to. And then they look at it and they say, no, no, well, not that. So that's basically what he just said. So on and for the bill.
Senator Steinmetz.
Thank you, Mr. Chairman. I wasn't going to speak on this bill, but having just recently purchased a property and gone through this process, I thought I might just provide a little bit of firsthand knowledge. So you go in, you have all these papers to sign, they provide you with your covenants and all of these things. And if the document's not going to change, I don't understand what this bill is going to do if it's going to historically still be there, because you go in, you sign all these papers, and you sign a paper that says you realize this doesn't apply. It's not a big deal. And of course, you're surprised to see that that is there, but we all know our history. And so I think we're making it a little bigger deal than it actually is. I don't really have an opinion on the bill, but I just want you to know that there is a process in place, having just been through it. It's not really a big deal with all the masses of papers that you're already signing. There's one that you sign that, you realize that this does not apply, nor would you want it to. And so just a little context of what we're doing. Thank you.
Senator Kinski.
And Mr. Chairman, just to follow up on one of our colleagues made the comment that it's the fact, what's really offensive is that people are having to sign on that they agree to abide by the covenants. And I don't recall any property I've ever purchased where I've closed through the title company where I was required to agree to abide by the covenants. I simply say, the title company says, here's your title, and it's subject to all easements, reservations, covenants, rights of way, everything else of record. At no point do they ask me to agree that the sewer line should or should not be going through my property. They're just telling me there's a sewer line, everything else on record, you're on notice that it's on record, but I've never had to initial saying I agree to abide by the covenants, Mr. Chairman, and perhaps other title companies have a different practice.
Senator Bouchard.
Thank you, Mr. Chairman. All the way at the beginning of the process, when you start the sales process, you actually have a document where you hand them the covenants, and you actually are getting them to sign a document saying that I've given you the covenants. So it's really starting way over there at the beginning of the sales process. So I want you to think about what's happening here. You get somebody that has a piece of paper in their hand, and as a realtor, you're giving them that document, and they're saying, what is this? And so look, this isn't going to just go away overnight, but because some of these properties are going to have to go through this process, and they will be sold, and this will be taken off. But while you have one of those in your hand and you have these unenforceable covenants, you're actually trying to sell this house, and you've got this covenant listed there. And now you got to start explaining it to the buyer that, well, not that. And that's because that's the point. That's all this bill is doing. It's very simplistic. All we're doing is we're saying, we don't want everybody to have to say, well, not that. It's taken off because it was already adjudicated that it was unenforceable by law. So that's the simplicity of it. It's a simple bill. I know it. Even I brought up the boogeyman. I take it back. It's not a boogeyman. Pass the bill.
Question being called. All those in favor of Senator Driscoll's Motion that when the committee of the whole rises to report, it do so with a favorable recommendation of House Bill 91, say aye. Aye. Those opposed, no. No. House Bill 91 has passed the committee of the whole. The next bill for our consideration is House Bill 20. Let's see, will the reading clerk read the bill?
House Bill 20 engrossed. Driver's license requirements, visual acuity, an act relating to motor vehicles, sponsored by the Transportation Committee, was referred to committee number 8, which returned to committee recommendation that it do pass. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Landon, chairman.
Senator Landon. Oh. There you are.
There, that's
Thank
greened
you.
up, Mr. Chairman. Thank you. Mr. Chairman, I would move that when the committee of the whole rises to report, it do so with a due pass recommendation on House Bill 20. And for an explanation of this little House bill, I would ask that you call on the senator from Campbell County, Senator McEwen.
Senator McEwen.
This is an incredibly complicated bill. We will probably spend hours on it. Mr. Chairman, this is House Bill 20. Basically, this changes the language in the driver's license statute to take the words "a vision test" out and add visual acuity according to the department rules. The beauty of this, none of the department rules have changed. We are literally just substituting adequate visual acuity for the vision test. And if you go through, it'll explain 15-year-olds can get a learner's permit. They have to take the visual acuity test instead of the vision test. You can still go to your eye doctor, or you can mail the results of a visual acuity test in and still get your license. So it really is just cleaning up the language with the bill. And with that, I'll stand for questions.
Senator Ellis.
Thank you, Mr. Chairman. If this is a silly bill, do we need it?
Are you ready for the question? All those in favor of Senator Landon's motion that when the committee of the whole rises to report, do so with a favorable recommendation of House Bill 20, say aye. Aye. Those opposed, no. No. Well, the chair is in doubt. All those in favor of Senator Landon's, please rise. Aye. 20. Okay. I still have to do all the opposed, right? I still have to call for all the opposed. Yeah. Okay. Thank you. All the opposed, please rise. Thank you. As per, House Bill 20 passes the committee of the whole. The next bill for our consideration is House Bill 29. Senator Driscoll.
House Bill 29 engrossed. Burials for indigent persons, an act relating to indigent person burial expenses, sponsored by the Corporations Committee, Was referred to committee number 7, which returned to committee recommendation that it do pass. Ayes, Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chairman.
Mr. Chairman, I move the committee of whole rise report that do so with the recommendation that House Bill 29 do pass. Further explanation, I'll call on myself. Folks, this is a fairly simple bill that kind of cleans up burial for indigent persons. Kind of work you through it. On page 2 is where we start into it. They go into existing statute, add cremation. Some of the counties have had a preference to do cremation rather than direct burial. You drop down on line 8 through 17, realigns the amount of money that can be paid underneath it. So not to exceed $1,500. Each board's account for the county expenses incurred under subsection during the fiscal year. Then by August 1st, they have to request reimbursement by the Department of Family Services for the expenses incurred under this subsection for the preceding year. So that's a reimbursement from the state back to the counties. Department of Family Service shall reimburse the expenses onto it. On to page 3 on lines 7 through 16. This goes back into the amounts. It says amounts once again won't exceed $1,500. Counts for it, goes through the exact same. Down to the bottom of page 3, this is the fees that they can impose for the section surcharges. In section B, said they shall collect a surcharge of $5 for each copy of the death certificate issued pursuant to the article. Revenues collected the surcharge go into an indigent burial account, which is a new account created. Funds within the account should be invested by the state treasurer, and all investment earnings from the account be deposited in the account, subject to appropriation, so we can dip back in and take the money. DFS shall disperse 1/2 of the funds to the account to the county, and the other half of the funds be available to DFS for their expenses and carrying it out. We go on to page 5, on line 3, they put in a provision to make it the funds only available if they're actually there. That's the long and short of the bill. I'd stand for questions.
Question being called. All those in favor of Senator Driscoll's motion that when the committee of the whole rises to report it, do so with a favorable recommendation of House Bill 29, say aye. Aye. Those opposed, no. House Bill 29 has passed the committee of the whole. The next bill for our consideration is House Bill 49.
House Bill 49, Agency Fee Revisions, an act relating to agency fees, sponsored by the Appropriations Committee, was referred to committee number 2, which returned to committee recommendation that it do pass amended. Ayes, Senators Guru, Hicks, Kinsky, Perkins, and Steinmetz. Senator Perkins, Chairman.
Senator Perkins.
Thank you, Mr. Chairman. I move the committee of whole rise report due with a favorable recommendation on House Bill 49 fee revisions. And for an explanation of the bill, we have me. So with that, we also had, I think there is also one amendment, which is a standing committee amendment, if I remember right.
Standing Committee Amendment number 1. Would be read in.
Yes, please read that in.
House Bill 49, Standing Committee Amendment number 1 to engrossed copy, page 1, line 1 after.
Thank you. So, Mr. Chairman, I'll go ahead and move Standing Committee Amendment number 1 to House Bill 49 and ask the body favorable consideration. We'll explain that as we explain the bill. As you go into the bill, and what you see here is we went back and we just went through the various revisions this year of the fees the agencies charge. And so it's pretty self-explanatory as you go down through there. You hit with, you've got confidentiality records. If you go down here, you'll find that you'll go probably the first one on page 3, line 7. You'll see that and this one's a little bit different in that we just allow it to be determined by amount determined by rule of the state agency. And that's because that there's an amount that they use and it offsets their costs. And so they only charge a fee that that estimated to recover the cost necessary to run that particular service and program. You go to the next page, you go to page 4, you'll see that they, again, where they're adopting some rules and allowing to set that fee, but there's a limit of not to exceed $500, which is an existing language. And then you come down through, you go down through, we've got the healthcare facility shall be assessed in the following fees. And you go down and look at these fees. And in each of these cases, so we went through this, each of the agencies came before us. Many instances, these fees had not been raised in 10, 15, and a lot of times 20, 30, 40 years since these fees had been changed in statute. And so as we looked at what's going on, and keep in mind, a lot of, for example, when you go into the healthcare, if we don't raise these fees, then you continue to reduce the amounts that get applied to the programs that we were cutting a week ago in the budget, or 2 weeks ago in the budget. And so ultimately, as these fees go, it does increase some revenue in some cases, and in some cases, it's just offset the cost of administering the programs in many cases. And so you go down, you can see the fees there. Again, you're talking about these different fees and what they do and how they're raised. And so that's as you go down through the bill, you get down to page 8, and you see some. You continue to see these fees as they've been raised. Like I say, we did these in discussions with the departments, reviewing how long it had been, what the fees were, some explanation of what the fee usages are for and what they do, and had consultation with the department. Oftentimes, these are the fees recommended by the departments with respect to how they should be changed. And so again, you come back and you'll find you're going back and forth. Sometimes there's a cap on them. Sometimes the fees are absolute. And the difference is that we did that in consultation with these agencies about whether or not and how those should be. In some instances, either the agencies asked for, in some instances, we wanted to be sure that agencies didn't charge fees in above certain amounts if they had some flexibility about how to charge those. And so we'll give you a minute to step down through there. And that's the effect of the bill is to clean some of this up and try and update the fee schedules for or charged by agencies across the state of Wyoming. With respect to the amendment that was read in, what we did here is there was as we talked, Mr. Chairman, one of the fees that was omitted from the original version of the bill was the fees that applied to agents' duty or to probationers and parolees. And there are certain fees that they charge for urinalysis and other things like that whether or not you would charge those. And quite frankly, there's several positions in the Department of Corrections that are funded by the ability to collect those fees. The concern was, at least initially, that some individuals may not have the money to pay for those fees. We took some testimony on it from the Department of Corrections. In addition, I confirmed that with the director of the Department of Corrections. And so we've narrowed this down to parolees and probationers, and for 2 reasons. One is that oftentimes, as a condition of probation and parole, they're required to have employment. And so these individuals are employed. They're not incarcerated. They're out on probation or parole. And so they are working. In addition, they're also, because they're fighting tax returns, are also receiving in some cases, benefits from things like current and last year and current year's federal legislation. So we determined that there is some ability to pay those fees going forward that help do that. Those fees in particular are used are part of the Department of Correction, and it's used to offset the cost of some of the probation and parole officers that are seeing them. Those caseloads are very, very heavy. We have there probably we've got probably, I can't remember the exact, I wish I could remember. We've got about 1,000 probationers out there. We have probation officers and parole officers are chasing around and their cast loads are very, very heavy. And so anyways, it's a continue to find a way to fund those programs and make sure that they're cost effective and also making, and quite frankly, it's a policy decision about having them pay for some of the costs associated with them being not incarcerated and working as a part of the condition of their parole. So that's what the amendment does. It goes back, you see it, is probation or parolee or other person committed. And there's a committee of the whole that will clean this up after because I did talk to the director after we did this, but it reinserts this language and this fee that's applied. And then it also deals with the distribution of the fee down below. And this is also discretionary if the department determines that they're unable to pay the fees because it imposes a substantial hardship, that these fees can be waived as well. And so that's what the amendment and the bill do. If there's, so we're on the amendment. So if we'll take questions on the amendment, if there are none, I'll ask for the body's consideration.
Senator Endicott.
Thank you, Mr. Chairman. We all know how I love felons. Just who these folks are that would be required to pay these fees. And this is a different type of fee. I just want to make sure that there's a clear understanding of the difference between this fee and the other fees we've looked at so far in the fee bill. These folks could go to prison for failure to pay these fees as a result. So as we know from the beautiful work of criminal justice reinvestment, that the greatest contributor to our increasing prison population is not the police, prosecutors, or judges. It's the Department of Corrections, Office of Probation and Parole, who is revoking them at a high rate and returning them to prison. That's the #1 contributor to our increasing prison population. So these fees and a failure to pay them could result, I believe, in the revocation of these offenders back into the prison system. So a failure to pay these fees and accumulation, I think is concerning. It is a policy decision, and I understand that they are taking from the system, that they took from society. But as part of that in their sentence, they are required to pay significant fees already. They pay a substance abuse evaluation fee. They pay a crime victims fee. They pay sometimes their public defender to a small amount. They usually pay for their drug treatment as well. So as part of this too, this is interesting to me because the drug screen testing, I think there's two concepts here. One is when the probation agent says, hey, I'm going to drug test you right now on the street or wherever, as opposed to their requirement to do their random monthly or weekly drug screening pursuant to whatever plan they're working. So it does start to nickel and dime them pretty heavily. Oftentimes they've just been released from prison or some type of incarceration and a job loss as a result of that felony conviction. And so standing them up is a little bit difficult. So just want to recognize the difference about this amendment. Neither for nor against it. Don't like the $100 transfer fee. But that it is more punitive and has much more of an impact for those that are required to pay that fee.
Senator Perkins.
Thank you. And I just, what she said is absolutely true. I would point to lines 19 through 22 of the amendment that read the department may reduce or waive any fee required by the subsection or suspend the monthly payment of the supervisory fee if it determines that the payment would cause a person significant financial hardship. And so I would just point that out. I would also point out that ultimately won't be included in this, but you have a number of people that pay significant amounts. For example, if you're out on alternative community corrections, you're paying that. You're paying usually somewhere about half of what you make while you're on alternative community corrections. You pay back towards the cost of having you at alternative community corrections. So it's not uncommon. It's a normal thing. And also one of the things that's also come to the light is, again, under some of this federal legislation, $600 last year and $1,400 this year that will be coming mostly to these individuals because they are working. And if they're working, then presumably they're filing tax returns. So thank you, Mr. Chairman.
Ready for the question? All those in favor of Senator Perkins' motion to adopt Standing Committee Amendment number 1 to House Bill 49, please say aye. Those opposed, no. The motion to adopt Standing Committee Amendment number 1 to House Bill 49 has passed. We're back on the division. Division being called. All those in favor, please rise. All those opposed, please rise. Be seated. The motion to adopt Standing Committee Amendment number 1 to House Bill 49 is passed, 17-12. We're back on the bill. Committee of the Whole Amendment number 1. To be read in.
House Bill 49, Committee of the Whole Amendment number 1 to engrossed copy, page 1 after line 15 in.
Senator Perkins.
Move Standing Committee Whole Amendment number 1, House Bill 49, and ask the body's favorable consideration. What this does, it goes back into the Standing Committee Amendment. This was after a telephone call I had with the Director of the Department of Corrections to make sure that we had this at the right people. So what we had, it was a little too broad, the language on amendment, the Standing Committee Amendment, lines 16 and 17 and 18, you see that a probation or parolee or person committed to the department who is supervised by the department. We just wanted to clarify that that's just after probation, we delete the comment, insert or after parolee or person. So now it'll just read that it is the probation or parolee who is supervised by the department. Just clarifies and narrows down who that was. It was too broad, Mr. Chairman. We were pulling in some people it was not intended to catch, like particularly people at alternative community corrections or that may be on split sentencing or other things like that. So it narrows it down the number of people to whom these fees would apply. Thank you, Mr. Chairman.
Question being called. All those in favor of Senator Perkins' motion to adopt Committee of the Whole Amendment 1 to House Bill 49, please say aye. Those opposed, no. Motion to adopt Committee of the Whole Amendment 1 to House Bill 49 has passed. We are back on the bill. Senator Perkins. No. Question being called. All those in favor of Senator Perkins' motion. All those in favor of Senator Perkins' motion that when the Committee of the Whole rises to report, do so with a favorable recommendation of House Bill 49, please say aye. Aye. Those opposed, no. House Bill 49 is passed to Committee of the Whole. Next bill for our consideration is House Bill 52.
House Bill 52, Wyoming School Protein Enhancement Project, an act relating to school nutrition sponsored by the Agriculture Committee, was referred to Committee number 5, which turned to committee recommendation that it do pass amended. Ayes, Senators Boner, Bouchard, French, Cost, and Wasserberger. Senator Boner, Chairman.
Senator Boner.
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with a favorable recommendation at Senate Bill 52. There is a standing committee amendment. I ask that it be read in at this time.
House Bill 52, Standing Committee Amendment number 1 to engrossed copy, page 3, line 3, delete.
Senator Bonner.
Thank you, Mr. Chairman. I move Standing Committee Amendment number 1 to House Bill 52. And for an explanation, both the bill and the Standing Committee Amendment, I ask that you refer to Senator Cost.
Senator Cost.
Thank you, Mr. Chairman. House Bill 52, Wyoming School Protein Enhancement Project. We'll present to you. It's a good project. I'm not going to say it's a good little bill because I've gotten in trouble with that already. Looking at the first part, an act relating to school nutrition, codifying a project that provides grants for school districts to increase the availability of Wyoming meat products in school nutrition programs, requiring matching funds, authorizing the Department of Education to accept donations and other outside funds as specified, requiring rulemaking and providing an appropriation and providing for an effective date. Sorry, see if I can get that right. On page 1 of line 11, Section 1, Wyoming Statute 2110-108 is created to read the School Protein Enhancement Project. What this is it's a project to allow protein through the meats that our state grows. It's increased from just beef to, if you'll look on lines 3 through 6 on page 2, the Department of Education may provide financial assistance to school districts to increase the quantity of Wyoming poultry, lamb, pork, beef, and bison used in school meals. Financial assistance shall be provided only to pay for processing costs for Wyoming poultry, lamb, pork, beef, or bison donated to a school district. This is to help keep costs down and also to provide good meals for our kids. The project shall meet program requirements. The department shall, contingent upon available funding, provide a match of at least $1 for every $1 contributed by school districts to pay for Wyoming poultry, lamb, pork, beef, or bison for the processing costs. The department, this is kind of important, the department may accept any gifts, contributions, donations, grants, or federal funds to specifically given to the department to support the School Protein Enhancement Project. So basically what we're doing is we're saying, okay, if people want to donate funds to the Department of Education for this project, or if they find grants, it's certainly available and they can apply for them without breaking any laws. Maintain the structure of requirements to the School Protein Enhancement Pilot Project for public school children as created by 2017 Wyoming Session Laws, Chapter 137. The department shall endeavor to provide funding to as many school districts as possible. On page 3, each school district may apply to the Department of Education for financial assistance under this section. And right here's where the amendment comes in, because there was a problem if they were to apply on or before June 1st, the 15th of each year. So it was simply to remove on or before June 15th of each year. So it now reads, each school district may apply to the Department of Education for financial assistance under this section, period. Application shall be on a form and in a manner prescribed by the department. And then you go on down to section 2 on page 3, line 10, up to $25,000 from any appropriation to the Department of Education in 2020 Wyoming Session Laws, Chapter 80, Section 2, Section 206 as amended is authorized to be expended as necessary to implement this section. It is the intent of the legislature that funding to the Department of Education sufficient to continue the School Protein Enhancement Project created in Section 1 of this act be included in the Department of Education standard budget for the immediate succeeding fiscal year. And with that, I would ask for your favorable vote. It's a great little project for especially those kids that need a good meal. And I would stand to answer any questions.
Senator Boner.
Thank you, Mr. Chairman. I have to apologize to the body. Even though this bill doesn't actually really do anything new, it's just, I guess, making a program that's currently in a budget footnote permanent. In spite of that, there is in fact an appropriation. So it should have been re-referred to committee number 2 appropriations. And so that's my mistake. So we'll go ahead and I'll ask that this be laid back until we can get it re-referred and back in committee of the whole.
We will lay back House Bill 52. Next, House Bill 54. Or is this just the amendment? It's a bill, okay. House Bill 54, Senator Boner.
House Bill 54 engrossed Wyoming Meatpacking Initiative, an act relating to agriculture and economic development, sponsored by the Agriculture Committee. Was referred to committee number 5, which turned to committee recommendation that it do pass amended. Ayes Senators Boner, French, Cost, and Wasserberger. No, Senator Bouchard. Senator Boner, Chairman.
Senator Boner.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, they do so with a favorable recommendation of House Bill 54. There is a standing committee amendment. I ask that be read in at this time.
House Bill 54, Standing Committee Amendment number 1 to engrossed copy, page 3, line 3, strike.
Senator Boner.
Thank you, Mr. Chairman. Ladies and gentlemen, this is House Bill 54. It's a product of our interim work on the Joint Ag Committee and talking about the continued efforts we have in the state to expand and make sure that our meat packing industry is more resilient than what we've seen. So good topic just before lunch here, I'd imagine. Mr. Chairman, what this does, it goes into the statutes that was created several years ago through, I believe it was called the Endow program. And part of that was a part of the program was dedicated to agriculture, and significant focus there was on increasing the amount of processing plants within the state of Wyoming. And that was somewhat a fortuitous work. As we all know, during the pandemic, we saw just how fragile this meat processing system really is. And so what this bill does is it kind of takes those efforts and takes the efforts that we've had in the immediate crisis with using CARES Act to increase the capacity of our meat packers, and it turns it into a more medium-term solution and moving forward, modifying what's already in statute and pressing forward with making sure that we can have some of those medium-term results. Obviously, there's other bills that have passed through this body that provide a more long-term solution. But what this does, it goes ahead on page 2. It provides some additional direction to the Business Council. This is talking about the Wyoming Business Council and their promotion of agriculture. And so it's going to say they're going to meet at least 2 times a year with the Department of Ag and the governor's office to, and like I said, we're basically just updating the current direction. They're not developing a strategy for small regionally located processing plants. They're going to maintain it. We're going to make sure it's for all meat processing plants, potentially not just beef. Once again, we're making sure that the Department of Agriculture is working together and that we are looking at a larger scope of plans for not just international sales, but in-state and interstate as the need for this increased capacity became more apparent. So we have other more expansion. It's not just Wyoming grown, but also produced products. So with that value added, we want to make sure that we can have other ag products, other types of protein coming in from other states that oftentimes, in order to make these businesses operation or economical, you have to have a regional focus, not just in the state. And just making some small changes, making sure that, we're not going to provide any loans or grants unless there's available funds. And once again, on page 3, that's very important through the Business Ready Community Program to be able to make sure that we're focusing on providing loans potentially for agriculture, just as you would any other business. And then we're getting into the standing committee amendment towards the bottom of page 3. We're going to come back to that in a little bit, but making sure that there are coordinating strategies to include technical assistance. That's a big deal when you look at the barriers that exist to getting a USDA or even a state inspected meat processing plant up and running. There's a significant barrier created by these regulations. And so any technical assistance that could provide could make a big difference in leveling the playing field. And so it's just making sure that there is in fact a program available for this priority within the Business Council, and making sure that they report back to the Joint Ag Committee at least once a year. So that's the bill. We can go ahead and process into the Standing Committee Amendment. At this time, and all that the Standing Committee Amendment does, Mr. Chairman, as it goes through and it once again broadens the scope of what the Business Council will be doing. Page 3, line 3, there's no need, once again, for loans and grants talking about increasing the amount of meat processing plants. There's no need to limit it to mid-sized plants when the goal is plants of all size, as stipulated in other parts of this bill. And then lines 17 and 19 on page 3, eliminating the somewhat arbitrary, from our perspective, stipulation there with when it came to the loans. Obviously, there's no other similar stipulations and statutes for any other type of loans with the Business Council. So that's what the Standing Commitment does. I'll stand for questions on that amendment.
Senator Scott.
Mr. Chairman, on this bill, as you all know, I'm in the cattle business. We sell the majority of our product through the sales ring in the conventional commercial channels. But we've gradually developed a business of raising and gradually expanding it, raising and selling 2-year-old grass-fed steers to the local market. And lack of meat processing facilities are a major problem. Frankly, it's one that is exacerbated by the fact the federal regulatory effort has been captured by the large meat packers and is being used to suppress small competition. Classic case of how government regulations can be abused. And this bill would result, if it succeeds, and I think it may, it would result in considerable benefit to my personal business. So, Mr. Chairman, I commend the bill to you, but I must declare a conflict of interest on it.
Senator Kingston.
Mr. Chairman, are we on the amendment, correct? We are
On the amendment. We are on the amendment. Standing
Question
committee.
on the amendment.
Senator Steinmetz.
Thank you, Mr. Chairman. And I too need to declare a conflict on this bill as we are working on putting in a meat processing facility. Thank you.
Question being called. All those in favor of Senator Boner's motion to adopt Standing Committee Amendment number 1 to House Bill 54, please say aye. Aye. Those opposed, no. The motion to adopt Standing Committee Amendment number 1 to House Bill 54 has passed. We are back on the bill. Senator Boner. Yeah. Could you restate, Senator Boner? It wasn't, the mic wasn't on.
Oh, I'll stand for any questions. If not, I call for the question, but it looks like there is a question.
Senator Biden.
Thank you, Mr. Chairman. Are there any meat processing plants possibly being done without state help? Or do all of these guys need state help in order to build one of these plants? Thank you, Mr. Chairman.
Senator Steinmetz.
Thank you, Mr. Chairman. All of ours is privately funded, and it's actually my son-in-law doing it. So yes, we are moving forward with private funding, but would hate to preclude the thought of maybe he may in the future not go all the way private. But yes, we are moving forward totally private. Thank you.
Senator Nethercott.
Thank you, Mr. Chairman. It's a great question. And I think it probably, there's a series of bills going through the legislature addressing this issue. One happened to be mine, passed out of this body, but it dealt with enhancing our antitrust laws associated with this action. And so what we know about the big meat packers, that there's 4, and they control 80% of this country's industry, 80%. And so when we look at the size of those corporations, in fact, probably globally as well, and they're not owned, some of them are not owned domestically. And so those are foreign countries dominating our meat industry and ag producers, that the small folks in Goshen County or other counties who maybe want to do this privately, that's who their competition is. And so that's a pretty hard sell. And then what we understand what they're doing is they are purchasing many of those processing facilities to the south, to the state south of us, and then just shutting them down, regardless of the economy. So even though that those are successful financially, they have demand and supply and are running profitable businesses as a result of the power of how they can manipulate that market, they're purchasing them, shutting them down, which of course has caused this reaction for why these bills are before the legislature now. But I think that goes to play. And do private entities, do our local ag producers need support in order to compete with the big 4 and others on that scale? Probably so, that in order to really make a place for the future of Wyoming's economy on this front.
Senator Boner.
And just not much to add there, but if you refer to, actually, there's a study that was commissioned as a part of the similar effort that came out last February, and it goes into just how much excess capacity we have just when it comes to cattle, how much is raised here and how much we process here. It's a fraction of the actual production that's actually processed in the state of Wyoming. So while I'm sure we could think of a state or USDA inspected plant that exists, it's not even close to keeping up with the demand due to a lot of the elements that have been discussed previously, whether it be the regulatory burden that is anti-competitive in nature, or even foreign governments putting their thumb on the scale of providing financial assistance or outright ownership of some of those big meat packers.
Ready for the Senator James.
Thank you, Mr. Chairman. So our solution is to use taxpayer money to now compete with private sector, like Senator from Goshen County. So I think this is a horrible idea in the fact that we're now thinking about doing this. So that's not a good way, because the government will just screw it up as they usually do. Thank you.
Senator McEwen.
Thank you, Mr. Chairman. We cut a lot of meat in 2 grocery stores. I think the biggest issue, what I like about the bill, other than we're going to give out loans and fund things, is getting around the USDA requirements. As a matter of fact, I can buy a cow from one of my neighbors. I can bring it to the store. I can slaughter it in the back parking lot, clean that up and throw it away. And as long as I cut it in a trailer and sell it in my parking lot, it's legal. But if I want to bring it into the store and cut it on a saw inside the store, I can't put it on the shelves because of USDA and state requirements. So I think as we go down this path, it behooves us to really examine regulations in the industry versus funding plants and playing the same game with the same requirements and trying to fight the four big boys. Thank you, Mr. Chairman.
Senator Driscoll.
Mr. Chairman, just a real quick correction, because we went down this path, food freedom. You can't butcher meat and sell it in Wyoming, basically. We've got a share type program, but it is illegal to butcher my own beef on my ranch and sell it. I can butcher it and give it away, but I can't butcher it and sell it. We've worked a lot of ways to get around this. And it's nothing against my good friend down the road, but we've fought with USDA nonstop over this issue, and we believe you should be able to, but we can't. So just a point of correction.
Senator Kirby.
Thank you, Mr. Chairman. Well, I want to let everyone know in our community, we have a brand new meat processing plant. It's doing very well, but I'm going to vote in favor of this bill because I still see parts of the state that are not covered by meat processing. So, but we do need to be careful about competition in the future. And once again, having government funds compete against private individuals. So thank you, Mr. Chairman.
Senator Boner.
Thank you, Mr. Chairman. Just a few clarifications. We're not beginning anything. We're not, this is, if you have a problem with the business council, and competing with the private sector, that's a broader philosophical issue. It's kind of outside the purview of this bill. This is simply updating current statute, as you can see if you read the bill. We're providing further direction as the situation evolves. We're not beginning to compete with anybody. As I stated before, once you look at the facts, there's a significant amount of additional work that needs to be done to ensure that we even come close to being able to process a portion of the amount of beef cattle alone that's produced in the state in a given year, much less any other type of commodity. So just want to make sure we understand what we're voting on.
Senator Steinmetz.
Well, maybe I'll bring us home here. So just to put things into perspective, I don't believe this program would be competing with us at all. In fact, I think it's desperately needed, and it's a win-win not only for producers and processors, but for consumers as well. Because when we went down this path was during COVID-19. And we went down to the local grocery store and looked at the supermarket shelves, and there was no meat. And we had steers standing in the corral 5 miles away, and we couldn't get them to our citizens when they needed them. And so that's where this process began for me. We never wanted to be in the meat processing business. We kind of like to keep our cattle alive, not kill, but here we are. So it's out of necessity. And just for the numbers, we sell about 999,000 head of cattle out of this state a year. There are 75,000 head on feed getting fattened in this state. We butcher 5,100 a year. And that's just beef. We're talking about other animals too. But that's what one of these big guys processes in one day. So our citizens need this, our communities need this, our producers need this, and I hope you'll vote for this bill, even though I can't. Thank you.
Question being called. All those in favor of Senators Boner motion that when the committee of the whole rises to report, it do so with a favorable recommendation of House Bill 54, say aye. Aye. Those opposed, no. House Bill 54 has passed the committee of the whole. The next bill, excuse me, I'll hold off there. Senator.
Mr. Chairman, I move the committee of the whole beg leave to rise and sit again.
All those in favor? Aye. Opposed? Yes, adjourned.
All right, no reports. So you've heard Mr. Majority Floor Leader.
Mr.
Oh.
President, I move we stand.
Whoa, whoa, whoa. Just a sec. Let's make the motion and then we'll do the committee announcements. Oh, re-referrals.
We've got a bunch of
That's what we have going on. Very good. Senator Boner.
Hey, thank you, Mr. President. I guess Senate File 52, Wyoming School Protein Enhancement Project kind of sort of has an appropriation, has to be re-referred to committee number 2.
Absent objection, referred to committee number 2. Senator Kinski.
Thank you, Mr. President. I've got a point of order question, and perhaps one of my colleagues can help me with
Little
it.
clarification then. Go ahead.
On HB 52, as previously, where we've had bills on committee of the whole that needed to go to appropriations, the instruction has been that we've got to come out of committee of whole to recommit or re-refer a bill. But I'm looking at our rule 6.0 or 6-3 committee of the whole procedure. Subsection B says, after either of the said motions have been made, which is when we rise and report that we do so with a do pass recommendation, it shall be in order to move any of the following, Romanet 3, to re-refer or recommit. So why would it not be proper in committee of the whole to re-refer a bill to appropriations? If somebody can help me, I'd appreciate it.
Senator Case.
It is a proper motion to do that out of committee of the whole, but it has to be done by motion. It can be done absent objection in when we're in session. So it is a proper motion.
All right. And a little further follow-up, I'm understanding now that it's in the rules, it's been there, but the president can make the call, and that's what we just did. Senator Anderson.
Mr. Chairman, I'd like to re-refer 2 bills that were assigned to us. House Bill 10, Large Business Relief, has a appropriation in it. I'd like to refer that to appropriations. And House Bill 67 has appropriation in it. I'd like to re-refer that to, House Bill 67 is geothermal and hydro. I'd like to re-refer that to appropriations.
Very good. Absent objection, House Bill 10, House Bill 67 re-referred to committee number 2 appropriations. Your turn, Senate, Mr. Majority Floor Leader.
Mr. President, I have some re-referrals. House Bill 107, Retirement System Efficient Distribution Method, has an appropriation in it. I would ask for it to be referred to committee number 2. House Bill 87, Provider Recruitment Grant Program, has an appropriation in it. Would ask to be assigned to committee number 2. And House Bill 135, House Hank Cole Memorial Highway, has an appropriation and would ask it would.
Mr. Floor Leader, would you repeat those numbers again?
House Bill 87, Provider Recruitment Grant Program, House Bill 135, Hank Cole Memorial Highway, and House Bill 107, Retirement System Efficient Distribution Method.
Thank you, Senator Landon.
Mr. President, House Bill 135, that Hank Cole Memorial Highway, originally had an appropriation in it. The committee has stripped that appropriation out. That is why I have not re-referred it to appropriation. But if they'd like to look at it, I'd sure bring it upstairs.
Mr. Floor Leader, would you like to revise your schedule?
Yeah, we'll just remove the Hank Cole one. I did not catch the off of that. I was dealing off the other.
And
We're running out of time, so we're trying to get these.
Understood. Repeat the 2 numbers you're re-referring.
Okay, it's going to be House Bill 87, Provider Recruitment Grant Program, House Bill 107, Retirement System Efficient Distribution. One of those may have been heard. I heard.
Thank you. For the record, House Bill 87, House Bill 107, re-referred to committee number 2 appropriations.
So we
Any
don't need to
other?
get re-referred then.
Any other?
87 has been already been.
We're narrowing this list down. Please, Chairman
Mr.
Perkins.
President, actually, we heard 87 yesterday, House Bill 87 yesterday. And so it's already been referred to and out of and reported back from appropriations.
Withdrawn.
So
withdrawn. So Mr. Floor Leader, are you holding strong to 107? For that referral?
Mr. President, I move we stand recessed till 2 p.m.
Absent objection, House Bill 107 is referred to appropriations.
Yeah.
Before we call for the vote, announcements on committees. Go ahead, Senator Baldwin.
Thank you, Mr. President. Early announcement tomorrow morning, 8 a.m. Your
Perfect 10 Committee, Committee 10, will meet at 8 a.m. Room 6 to hear House Bill 217 Community Health Center and Rural Health Clinic grants.
Chairman Perkins.
Thank you, Mr. Chairman. Mr. Chairman, your Joint Conference Committee on House Bill 1 will meet with a light committee at, during the, as soon as the light committee from the House can meet in the Joint Appropriations Room 301 to begin the conference on HB1.
We wish you all the best with that endeavor. Senator Boner.
Thank you, Mr. President. Your committee number 5, agricultural, will meet upon adjournment today in Capitol Center Room W2 and online to consider House Bill 188 irrigation district loans, House Bill 229 livestock identification choice act.
Thank you. Any further announcements? Any further announcements? All right, you've heard the motion. All those in favor say aye. Those opposed, nay. The Senate will stand